Hi, my name is Lori Conroy. I'm an assistant United States attorney. I work for the Department of Justice. And today I'm here to offer some suggestions and what I think are best practices for prosecution of cases involving child abuse. In my experience, attorneys either love, hate, or overlook jury selection. But it really is one of the most important pieces of trial, and it is something that should be carefully prepared for, just as you do every other aspect of trial. Your preparation should begin by knowing what your court expects in jury selection. You should know the rules of criminal procedure. You should know the local standing orders and any trial memos that your judge has put out for attorneys to follow. You can also ask other attorneys who've had trial experience in front of the particular judge, and you can ask the court herself. When you have a status conference, ask what the expectations, what the boundaries are for jury selection. Specifically, ask how prospective jurors will answer sensitive questions. In cases of child abuse and child sexual abuse, oftentimes jurors will have personal experiences, and they may not feel comfortable in the courtroom setting discussing those things. However, there has been some recent case law on courtroom closure that may create a post-conviction issue if you don't adequately address courtroom closure. It is suggested that you have jurors answer sensitive questions in open court. If they're uncomfortable doing so, you could ask that the rest of the potential jurors leave the courtroom, but the courtroom remain open. Or you could ask that that juror answer the questions at sidebar where the courtroom is still open and people can at least observe the juror. Alternatively, you can ask for the defense to waive the Sixth Amendment concerns that might come with a closed courtroom. Also find out the order of the questioning and the manner of the questioning. Some judges say that because the prosecution has the burden, they go first. Others say because the prosecution has the burden, they go last. If you have this basic information, that will help you time and create the content of your questioning. You should also carefully review the information about prospective jurors. Each jurisdiction is a little different. You may just get the first initial and last name of the prospective juror. You may get some brief biographical information, such as year of birth and employment, if any. Whatever information you take, use open sources to find out a little bit more about the jurors. Run them through the publicly available information on ND Courts. You're looking for interactions with the criminal justice system. Also be aware of the really small communities that we operate in. You may have jurors who are related to court staff, judiciary staff, the parties in the case, the attorneys, or they may know other jurors. You're going to want to know this information going in. Think about the theme of your case and how you can explore that in jury selection. Again, within the confines of the rules that the judge gives you. But really, your theme should start in jury selection and should carry on throughout the questioning of each of the jurors and then come full circle in the closing argument. Now, child abuse and child sexual abuse is a topic that many people have strong feelings about, and many people have personal experience with it. You should explain, unless someone already has by the time you stand up to do your questioning, that jury selection is also called voir dire, which means to speak the truth. And that what you're really looking for in jury selection is honest answers so you can determine whether or not you have fair jurors who can listen to the evidence, listen to the law, and fairly determine what the defendant did. You can explain to jurors that bias is not a pejorative. We all come into a courtroom with bias. Bias is based upon how we were raised, the experience we have, but there may be something about their particular experience that might not make them the right juror in this case, and that's what you're trying to determine. Explore the general themes that exist in child abuse and child sexual abuse cases. One example is forensic evidence or lack thereof. Many of these cases are historical disclosures. The average age of disclosure of child sexual abuse is in the 50s. So you may not have corroborating forensic evidence. That's something to be explored through questioning. Children as historians. Commonly, people have experience with children, either their own, their grandchildren, working with children, and you may want to ask some questions about how children remember things, how children relay things that have happened to them. One topic that is a must in my experience in child sex abuse cases is speaking about intimate things like sex, hurtful or embarrassing things in public. I like to set up a theme in jury selection about how difficult it is to talk about those things in a public setting, such as a courtroom. So when you later have a child or even an adult who's relaying experiences that happened to them as a child, you can go back to that in closing argument and have the jurors recall how they felt when they were asked about those things, and use that when they're judging credibility of the child or the adult who's testifying. Think about whether your case involves use of controlled substances or intoxication. Explore with jurors whether their feeling is that a controlled substance or use of alcohol creates an excuse for behavior or if it's a reason for behavior. And judge accordingly whether that person can listen to the facts in this case and be a fair and unbiased juror. One of the themes I always explore in child sex abuse cases is where it happens and why. Jurors should begin to understand in jury selection that these things often happen behind closed doors, away from other eyes, away from surveillance footage and other things that might record it, and the reasons for that. You want to begin exploring that theme so then a juror isn't questioning why wasn't there more evidence beyond what a child and other corroborating evidence says. Physical abuse. Think about what parenting tools may or may not have been used for those potential jurors. Corporal punishment, spankings, other kinds of discipline, being sent to bed without a meal. And if your case involves physical abuse or neglect, explore with the jury when that flips from discipline and good parenting into criminal conduct. Get a sense for their feelings on these important themes. Ask about when is a ripe age for a child to be left alone or in the care of other children. And be sure when you're asking these questions, you're asking about both a juror's personal and their professional experience. You may have jurors who are mandated reporters, such as nurses, teachers, social workers, and be sure that you explore these themes with them in both their personal and their professional setting. It's very important to keep track of hands that are raised, nods that are given when you're looking at the jury and asking them about these questions. Be sure that you make a record of each juror who spoke and come back to them and ask them if time allows. That will help you if there are later challenges following conviction to not exploring a possible bias or other things about a potential juror. And once you've had the full opportunity to listen to the answers to questions asked by the court, by the other attorney, and to your questions, know and understand the law of preemptory challenges and your other strikes, and exercise them effectively.